Yes.
Please, Your Lordships. I'm sorry, there was one small point that I omitted on Article 16 and abuse in trying to skip over that. Can I please go to that? It's in Authorities 4, tab 47.
Yeah.
It follows on from the suggestion that Article 16(1)(a) would be an effective anti-abuse provision in the circumstances that we've described. Can I draw attention, please, to 16(4) again? I've referred to this already, but to point out that the decisions to withdraw or refuse reception conditions as sanctions for abuse have to be taken individually, objectively and impartially. So there are 2 points to draw from that. One is that in respect of all the things which we say don't make sense in the earlier parts of the directive, for example, information and documentation and so on, it wouldn't be permissible on the face of 16(4) to have a general policy of saying if you last made an application within the last 6 months, we're not going to give you the further information again. So it doesn't work for that. And the second thing is that if you are faced with somebody who is abusing the system by going over and over again, this places quite a burden on the decision-making system to have to look at the case every single time to decide whether or not you're going to withdraw those benefits. And the burden on the system is, of course, one of the problems that there is in any event.
And you can't opt out of this. I mean, obviously, the Article 16(1) is, as it were, an opting out provision, but 16(4) is a rule that has to be applied every time, is it?
It is, yes. So if you're faced with somebody who is determined to make abusive applications triggering this, you're going to waste resources on deciding to withdraw the reception conditions every time. And of course, the more people who abuse the system and require this use of decision-making resources, the slower everything gets for everybody. And so 16(4), even if this is the way to do it, is not a very good solution. Can I then move on, please, to the Dublin regulation? It's a very short point to make. The Court of Appeal at paragraph 66 drew attention to this, but without parties having argued it. If your Lordships have it in Appendix Part 1, paragraph 66 is on page 20 of the Appendix, page 2493 of the report, just by letter D. Lord Justice Hooper says, we were not referred to the Dublin regulation in argument. The first part of the preamble is in similar terms to the preambles in the 3 asylum directives. The words applicant or asylum seeker are defined in Article 2D in the same way as they are in the reception and procedures directives. It seems to me, but without the benefit of argument, that a person who has made a subsequent asylum application in country A, in respect of which a final decision has not yet been taken, is a person who has made an application for asylum in respect of which a final decision has not yet been taken, and is thus likely to fall within the ambit of the Dublin regulation if he went to country B and claimed asylum there. So what Lord Justice Hooper was thinking about was a person who has been through the asylum system once in country A, makes a second application in country A. That's where he says a person who has made a subsequent asylum application. So he's making the second application in country A, and then going to country B and claiming asylum there. I think that all of us are agreed that for the substantive point, there's very little that can be got from the Dublin regulation. But for the reasons that we've set out in our printed case, this isn't actually the way the Dublin regulation works. It works because the country A is the allocated country for deciding the asylum application by virtue of the individual having made his first asylum application there, not the second one. And so Lord Justice Hooper's focus on the second asylum application was, with respect to him, mistaken. But further than that, that point does not assist.
I don't understand the respondents who are trying to get anything out of the Dublin Convention.
No party is, and so that's a point that's entirely neutral. Can I then come on, please, to the Procedures Directive? This is in Authorities Volume 4 again, tab 49. We've already made the point that this directive has a different...
I'm terribly sorry, Mr. Town, I'm sorry. I mean, just before we move to the procedure, I mean, is there anything that you, so to speak, want not to have to give second-time asylum seekers under the reception directive, except this different approach to employment under paragraph, whatever that one, is it 11?
11, yes.
Yeah, I mean, is there anything else that you actually want to ensure they don't get the advantage of? I mean, these things like 5 and 6, I mean, you say, you know, they don't apply or whatever, but I mean,
Yes.
it doesn't much matter either whether they do or don't.
Well, one should never say never. It is interesting that this point has only now, after 5 years, arisen in the context of permission to work, and that's clearly the incident that has triggered examination of this question. But there are a number of provisions. We haven't gone on beyond 11, but there's 12 vocational training, 13 and 14 dealing with material reception conditions, which includes things like accommodation and support, and 15 healthcare. And the whole raft of those would then be governed by the reception directive. Obviously, these individuals are being provided for in any event by domestic legislation. The direct concern relates to employment, but it would be a side effect that we would find that all of the other parts of the directive serve to regulate everything that the Home Office does for the failed asylum seekers.
But I mean, it's a point taken against you that if you're right about this point, these benefits like healthcare are simply stripped away from the second-time asylums.
With respect, not stripped away, they are simply no longer
they
provided.
are as far as the directives are concerned. Okay, as we discussed before, the UK provides them, but it doesn't have to, and some other member state, yet more impoverished than we are, may not do so. Now, is that appropriate?
It would be difficult to imagine a member state not providing a level of healthcare that satisfies ECHR requirements. In fact, they have to do that. It would be difficult to imagine any member state that would be subject to this directive not making adequate provision for failed asylum seekers who are seeking to go the second time round. The difference would simply be that it is not governed by this particular package of measures, which we say is aimed, primarily at least, at the first time round asylum seeker.
Yes, but the question is, if Europe has seen it fit to prescribe this minimum standard that must be translated into domestic law by all the members of the EU,
Yes.
why would it refrain from doing so in respect of second applicants?
Because that there are legitimate differences to be drawn between the position of those who are applying first time round, who, as I've said, they come afresh. They may have a perfectly genuine claim which has never been tested, and the member states have decided that this is the level of benefit and support that they should have as a package.
So
However,
in other words, it had in contemplation that there were perfectly legitimate claims, and simply because of the circumstance that they were a repeat claim, then all of these benefits, which were considered to be the minimum required, could be legally withheld from them.
Lord, with respect, we would not accept the description that it's simply because of the circumstance that they're repeat claims. It is a very important part of the factual background that they are people who have already had one full go at establishing their asylum claim and failed. And we know from experience that in that category of people, there is a different outlook. They are entitled to be treated differently because they are in that different factual position. And there is no problem in principle with providing a different package of measures to support them during that period. That would be the effect of the success of our argument, not that they would be left destitute and, on the streets. The provision that is made for them would simply come from different sources, not from this directive.
But the minimum standard would be lower for repeat applicants than for first-time ones.
Well, it would be legitimate for the standards to be lower, yes.
Because if you look at the recital, I'm not sure we looked at recital 15, but that seems to me to be an important recital to have in mind. It is in the very nature of minimum standards that member states have the power to introduce or maintain more favourable provisions for third-party national status persons who ask for international protection. It's quite a general aspiration.
That's given effect in Article 4.
It is, that exactly so, that this recital 15 and Article 4 are basically providing that the directive's package is a minimum for the people who fall within its scope. And for the people who fall within its scope, if the member state chooses to provide more for them, it is perfectly at liberty to do so. So that's why I say it's not a code, it's a minimum. Yeah. But there's no reason in principle why a person who is coming to this second time around must be afforded the same package of measures. That person is already in a different position because he has been through once and failed. And the whole context is, by that stage, different. And there is no reason in principle why he must be afforded all of these benefits simply because he has asked again, in whatever form and with whatever merit or lack of it, for protection.
Could we just look again at Article 2b, the definition there of application for asylum, because Sir John's question reminds me that the second sentence there rather picks up paragraph 50 of the preamble, because it says any application for international protection is presumed to be an application for asylum, unless, and so on and so forth. And the word any, I think, is drawn to our attention by the respondents and say, well, it's broad enough to cover second applications as well as first, yes. And they ought to be treated as applications for asylum. Yes. Well, what's the answer to that?
The answer to that, we've set it out in our case. The answer to that is that this provision simply helps those who have, perhaps unaided, made an application which is unclear in its content. And this is a provision which says, whatever application you make that looks like an application for international protection, it is presumed to be an asylum application within this, unless it is something else. So it isn't saying that it isn't a deeming provision in the sense of making anything an asylum application for these purposes. It helps those who have, perhaps without any assistance at all, written in to say, help, I need protection. And that's what that is there to do.
And there's just one other point on this directive before we leave it that occurs to me. We were looking at Article 6 about documentation. And there is a sort of flavour here, particularly in Article 6.4, of providing documentation that will remain valid for as long as they are authorised to remain in the territory. And authorisation can come and go, I suppose, I mean, depending on the present state of affairs as far as an application is concerned. There is a sort of resonance in Article 19.2, which deals with unaccompanied minors. And there you see it spelt out that if they make an application, they shall, from the moment they're admitted to the territory to the moment they're obliged to leave, be placed, and so on and so forth, so that they are catered for throughout the whole period of time. Now, yes. That would run over, I suppose, a period during which repeat applications are made. if you've got the terminus antiquem as well as the arquo set out there. So it's broad enough in their case to cover their remaining here during a period between the time when the first application has been disposed of and the second one has.
Certainly, in terms of the period for which the benefits must be provided, that provision, like Article 10, extends beyond the final determination of the asylum claim.
Yes.
But that doesn't answer the question, what do you need to do to trigger that provision? And that is the issue in the case. And we say that the repeat application does not trigger this provision. 19.2 is, if you like, another demonstration of why it is unnecessary in that particular category to trigger it again, because that is a right which is already provided and is continuing. Just like 10.1 is provided from the initial application and continues until expulsion. And as we've pointed out, the notion that that right is triggered again by a repeat application is inconsistent with 10.2.
Right, so we're going to look at the Procedures
Directive, and that's tab 49 in the same bundle 4. We've made the point that this covers a different purpose. It is setting out mostly the administrative measures for determining the substantive content of the, determining substantively the asylum claim, rather than the protection and support provided in the interim. We've also made the point that it came substantially later in time, so that if the Reception Directive had already the meaning for which we contend, this can't have amended it by a sidewind. In terms of its structure, the Lordships are already aware that the definitions are in the same or similar terms, and that there's nothing that I can get out of those, and I've made the submissions about the scope of each of the directives. But what we do draw attention to is the way the structure of the decision-making process is set out. And this starts at Article 23, which in the page number in the top left-hand corner is 326/24. Um, 23 sets out at some length the examination procedure for applications for asylum. One sees that might or might not cover a second application. But what the draftsman of this directive has done is, in a couple of places, bolted on specific provisions that deal with second applications. And so you see at 24.1a, under specific procedures, member states may provide for the following specific procedures derogating from the basic principles and guarantees of Chapter 2. A preliminary examination for the purposes of processing cases considered within the framework set out in Section 4. And if you go on to Section 4, which is Article 32, page 326/28, you see that the first article there is subsequent application, and there is then a set of specific provisions relating to subsequent applications, including the possibility of a preliminary examination which is permitted by Article 32.2 and whose content is described in 32.3. And the consequence of the preliminary examination in 32.4.
There is a provision actually in 23H, which refers to subsequent applications, isn't there? I mean, that
Yes.
allows them, which deals with the case where there's a procedure to be accelerated if there's an application of that kind.
Indeed, that's right. So one can see in 23, and then followed on in 24(1)A and then 32,
Yes.
specific provision being made by the draftsman for subsequent applications, showing that he had subsequent applications in mind when drawing up the text of this directive. And then went on to indicate how, if it wasn't already clear from the specific text, how the provisions are to be applied in the case of subsequent applications.
And the distinction between further representations and a subsequent application in this 2.1 is further representations in support of an extant application which has not been determined. Is that what that's about?
Yes, well, I'm not sure that further representations is specifically defined, but it is, well, there are two terms which put together contemplate a type of submission that is being made to the member state concerned. That is to say, not my initial application, not my first time round application, but this is more that I want to say at a later time.
It's interesting, looking back at Article 23(4) little e, that it envisages a situation that he might have found another application stating other personal data. I mean, this is a point you were making before, that if you're looking at 16 of the other one, that's the kind of situation where you give data different addresses, different names, whatever it is, and the two might be confused. And there should only be one application, not two.
Yes. Exactly so. So the draftsman by now explicitly recognises that situation, which is one that is not uncommonly encountered. And if you look at that situation and read it back into, or look back at the Reception Directive 16(1)A third tier, one can see how that fits in there, how that might well have been what is in contemplation. Because if you make this sort of subsequent application or second application, then it is the sort of abuse which is of a piece with the other categories in 16(1)A, and it is a kind of abuse to which those concluding words in 16(1)A are applicable. So there are two points to draw from this. The first is, of course, I think just to reiterate, but now that we've seen it, these are the sorts of provisions which the draftsman of the Reception Directive could have made if he had in mind the second application as well as the first application. And if he had been thinking about second applications when drawing up the Reception Directive, he would surely have said something about it, because otherwise we are left with those rather odd effects of the text that we currently have. So that's the first point. But the second point is this. You can see how the Procedures Directive allows for accelerated procedures to be adopted, preliminary examination and prioritisation in 32 and 23(4) respectively, where people make subsequent applications. The intention of that is obvious, to deal with these as fast as possible, because many of them will be totally unmeritorious, the individual having already been through the system once already. But if my learned friends are right about the reception directive is saying, we don't care at all. The reception directive simply does not care at all about the merit or the number of applications or the frequency with which they are made. Every time, the whole panoply of reception directive rights is triggered. And we respectfully say that that is an odd conjunction to have, given that the Procedures Directive itself recognises that subsequent applications do need special handling or can need special handling, and that member states are entitled to make special provision for them. And that, we say, is a strong indication that the Procedures Directive, when it makes special provision for second applications, was obviously doing so deliberately and covering a wider field than the Reception Directive covers.
Yes.
So, Lord, they're the points that we make from the Procedures Directive. There are two final points about construction before I turn to the question of a reference. The first one comes from, or is helpfully set out in MM's printed case at paragraph 5, which quotes from a piece of Home Office policy on this. The policy instruction quoted at the bottom of the page is, if a failed asylum seeker makes a fresh asylum claim, then provided it is accepted as a fresh claim, the procedures set out above should be followed, which includes being entitled to apply for permission to work. Learned friends suggest that that might be an indicator that we accept that the Reception Directive applies in some circumstances to second claims. The point that we make is simply this: that is something which is not required by the Reception Directive, but it is something that we do as a matter of policy, which is more generous than what the Reception Directive, strictly speaking, requires. There's no inconsistency between our approach and the argument that we advance.
You say it's an Article 4 situation?
That is, exactly so. Although it is not actually Article 4 itself, because we say this is entirely outside the scope of the Reception Directive, but certainly it is the type of thing which Article 4 and the more general principle in Preamble 15 contemplate.
I mean, that's the same point as the subject of, I think, paragraphs 14 to 19 of the Court of Appeals judgment.
Yes.
I mean, they specifically quote that same asylum policy instruction.
That is right. But if it were to be said against us that this is some sort of indication that our policy and practice are inconsistent with our argument, we respectfully say no, because the directive sets out minimum standards in a limited field, and this is an example of something which is not required by the directive, but is being provided as a matter of policy. And in fact, the last point I think I've actually managed to cover, which is the question of minimum standards for people who fall outside the Reception Directive, which one finds from elsewhere. For example, the ECHR, and indeed a great deal of domestic legislation, which makes provision for these categories of people. It is not a case where, if the directive does not apply, they are somehow left in limbo or left in an unsatisfactory position. They simply have a different set of benefits and support measures that happens not to be provided by the Reception Directive. Can I then turn from the substantive point of the construction of the directives and deal briefly with the question of a reference, if your lordships are...
Sorry, just before I'm sorry. I mean, here we have under the Procedures Directive these specific opportunities to give cursory or initial or preliminary examination, whatever it is, to, I mean, I'm looking at 32.3, a subsequent application shall be subject first to a preliminary examination, basically as to whether it is a fresh asylum application. Yes. Is that what it is?
It's another example of odd wording. The way that 32 works is this. 32.1 deals with being permitted to consider the further representations or the subsequent application in the framework of the existing or the previous application. 32.2 says member states may apply a specific procedure as referred to in paragraph 3, where a person makes a subsequent application for asylum in the two specific situations. And what 32.3 does is it describes that specific procedure that the member state is permitted to invoke if it wishes to do so. So although 32.3 is written in mandatory terms, you have to read that with 32.2. 32.2 giving you the permission to adopt the preliminary examination procedure which is described in 32.3.
I know, but what is it that they are making this deciding by preliminary examination whether new elements or findings relating to the examination of whether he qualifies as a refugee have arisen or have been presented?
Yes.
I think it's then followed by 4, is it, that if you, having got that far, you then look to see what the prospects of success are, in effect.
Indeed. Yes.
And if they significantly add to the likelihood, then you look back to chapter 2.
Indeed.
Is that right?
So it's the preliminary examination is a sort of screening measure to see whether there's anything that's been added to what's been said previously.
And if there isn't anything, then that end of subsequent application?
Indeed. That's the intention.
Subject, I suppose, to paragraph 5, 32.5. It might have something
yes.
more generous in.
Yes, and obviously you can do something more generous, and indeed we don't have the screening procedure set out there at all. This is something which member states are permitted to have, but not obliged to have. But what is clearly being contemplated is the ability of a member state to do or to look at subsequent applications and decide them very quickly if they don't in fact raise anything new. So it's trying to accelerate the processing of repeat claims so that they can be dealt with and individuals removed if they don't qualify to remain. That's the aim of this. But we say that if that is right, and if that is recognised by the Procedures Directive, why should it make any sense for the Reception Directive to require rigidly all of those benefits to be triggered every single time further unmeritorious representations are made? That is an oddity if you read these directives together in the way that the respondents ask you to.
I mean, I'm not sure I'm following that. I mean, why, having taken this followed 32, you decide they don't significantly add? End of story. I mean, why isn't it end of story under the Reception Directive too? Why doesn't that then meet the situation and that's it? And now the person can go. Now, say they reapply. Then I suppose again you take a short cut, but I mean...
You would take a shortcut, but before you get to taking the shortcut, you have to do everything that the Reception Directive requires of you. And if next week he does it again, you have to do it all again next week. even if what he's put in is exactly the same as he's put in this week.
I mean, what is it in the reception directive which says you can't immediately remove? Is there anything which says that, having reached an Article 32 decision under the Procedures Directive, you can't immediately then remove?
I don't think there's anything in the directives that says that, but as a matter of practicality, it will always take some time to effect a removal. And it is a common experience that even if your removal is going to be in 36 hours' time, that's ample time to put in another set of further submissions, even if they're just a repeat of the previous ones. And what Malone and Friends are contending for is that at that point, the whole of the reception directive becomes applicable once again.
Are you saying that in an extreme case, you can have repeat applications, one following quickly upon the other, covering exactly the same ground? I mean, never mind the benefits, but simply because for some asylum seekers, it's simply that they don't want to go back, and that the state is completely helpless to deport such a person.
I don't suggest that the state is helpless to deport the person. If sufficient measures are put in place, the deportation or the removal could, I'm sure, take place. The problem is with the conceptual difficulty of the whole of the reception directive applying or being triggered once again every time the repeat submissions are put in. That is why we say there is something very odd about the hardline literal approach which the respondents take to the construction of the reception directive.
But in practical terms, will that actually add a further layer of delay? I mean, it's perfectly possible for unscrupulous applicants who wish to avoid being removed to make repeat applications. And such is the system whereby those are received by the state, they have to be dealt with. And surely what you must try to persuade us of is that there is not only this incongruity to which you refer, about all of these, as you put it, all of these directives, all of these provisions coming into force, but in practical terms, does it add, or should it add, to the delay in processing the application?
Well, it would certainly add an administrative burden, if nothing else, in terms of the provision of information in redocumentation of the individuals every single time that this happens. Yeah. This is a context in which any added administrative burden would be highly undesirable because it jeopardizes a target which it's an important one to try to meet. And that's quite apart from the illogicality, we respectfully say, of adopting that position as a matter of hardline principle.
Well, the framers of a reception directive obviously had in mind the possibility of abuse. I mean, that's clear enough from paragraph 12 in the recitals, isn't it?
They did have in mind the possibility of abuse, but you can get abuse at every stage. And what we say is that the abuse that they had in mind was abuse within the first time round application. And you get that because there are examples of that set out at 16(1)(a).
Does the procedures directive, does that have any of the recitals there discuss abuse?
Sorry, any recitals?
In the procedures directive? I imagine there are some, but I'm just looking.
No, we'll have a look, but not myself seen those. Yes. Recital 15, I'm grateful to my friends. Recital 15 refers to subsequent applications that don't present new evidence or arguments, but it's not in itself quite necessarily abusive.
Well, it does recognise that there is an abuse, in a way, in repeat applications which don't add anything. And the way in which the Procedures Directive copes with that is to say, well, you don't have to go through the whole process. You can short-circuit it.
It certainly recognises that, and it gives a mechanism for dealing with it, whether the second application is abusive or not. But this goes to show how the drafter of the Procedures Directive clearly had in mind the problems of second applications, the types of problem that they throw up, including the fact that sometimes they are mere repeats without adding anything additional, and has then made special provision for those subsequent applications and given member states a way of dealing with them that is practical and doesn't it doesn't oblige the member state to go through the whole thing again right from the beginning every time somebody makes a second application. And we contrast that with the Reception Directive. And I've said this many times, the Reception Directive is simply silent about all of this. And not only is it silent, but it is difficult to make its provisions work for second-time applications.
I mean, I don't understand if your worry and concern about endless repeat applications, why doesn't that apply equally under the Procedures Directive? I mean, what's to stop somebody? They make a second application, it adds nothing, and so you deal with it on this, you short-circuit it. Yes. But it's still going to take, I don't know, weeks, months, whatever it is. Then they make another. I mean, what's to stop them doing that?
Well, the member states have always had to deal with the substance of the application because other treaty obligations oblige them to do that. And that's a fact of life.
Just take a case. There's an application, it fails. It's gone to appeal, it fails. There's a subsequent one. The state puts in place the Article 32 process for a preliminary examination, and it decides that there are no new elements or findings which significantly add. Okay? And they communicate that decision. And the chap says, well, here's another one, try this. They have to go through it again.
They do.
Meantime, are they, presumably, can they get rid of him? Can he be deported?
Well, the state may ultimately have to act in a very expeditious way and deal with mere repeat submissions, perhaps by return of facts on occasion, so as to dispose of them before actual removal.
But if they've got to do that under this other directive, I mean, why can't they do the same thing under the Reception Directive?
It's not that it would be impossible for a member state to do that. But there's a huge distinction between dealing with the substance of somebody saying there are these international law treaty reasons why you cannot remove me. It would be a breach of the Refugee Convention to remove me, or outside this context, it would be a breach of the ECHR to remove me. Those treaty obligations, the state is going to have to deal with anyway, so the state must gear itself up to deal with that. The Reception Directive is different because that is dealing with peripheral matters. Perhaps not quite the right word, but ancillary matters. They are dealing with the conditions and the support and the benefits which the individuals should have, while real application is being dealt with. That is what it is aimed
I
at.
follow that, absolutely.
And we respectfully say that while it's not impossible that the state could put in place procedures for dealing with the effects of that if the reception directive is construed the way that learned friends seek to argue, it doesn't make good sense to do that. And because what's in the reception directive is really not aimed at these people.
Yeah, but I'm sorry, I mean, it has to put it all in place if it's actually going to get rid of these people under the procedures directive.
Well, the state will have to look at the substantive application. And that's something the state cannot get away from. But the state does not have to go through the whole reception directive procedure every time, unless it's binding. But there is no pre-existing requirement for the state to go through the whole of that process every time somebody makes further submissions. That is why it would be an additional burden on the state to hold that the reception directive applies every single time that further submissions are made. And and I think the final point to be got from the procedures directive is one particular category of application which might be called abusive, which you find described in Article 25 of the Procedures Directive, which is page 326/25, which is a number of types of application which are regarded as inadmissible. Nevertheless, the Procedures Directive treats them as applications, even if they can be dealt with summarily. And again, on Learned Friends' approach, an inadmissible application made second time round would also trigger all of the reception directive conditions.
Is that one falling within an Article 25 2F? Is that what you have in mind?
Well, it's any of these made after the final disposal of the first application. They're all inadmissible, or the member state is permitted to regard any of them as inadmissible. And as a matter of principle, the reception directive, or it makes little sense for the reception directive to apply where the subsequent application is not just bad, but inadmissible.
Sorry, let me just see if I follow this one. I mean, assume an identical application after a final decision. No problem under the Procedures Directive. What happens? I mean, the Secretary of State simply ignores it, does he?
Yes, or treats
Inadmissible.
it as inadmissible and rejects it.
What?
Treats it as inadmissible and would reject it on that basis.
But what are you suggesting? You may be right. I mean, is the suggestion that under the Reception Directive, if the respondents are correct, because there isn't any provision for treating them as inadmissible, as under Article 25 here, they have to give effect to them?
Well, it would trigger the Reception Directive all over again. Just the making of that inadmissible application would, on Learned Friends construction, trigger the Reception Directive once again.
Even if it's identical? Even if it's identical?
Even if it's identical. Because the Reception Directive simply has no way of dealing with these matters.
But I mean, surely, the solution should be that, if it is inadmissible under the Procedures Directive, or indeed if it is the subject of one or more fast-track rejections, because there's nothing effectively new under the Procedures Directive, under Article 32, the consequence of that should be, okay, out he goes, and then we can forget the Reception Directive, that is history. But if, because of our own rather quixotic way of dealing with these things. The chap actually is going to stay out here for 4 or 5 years because nobody does treat it as inadmissible or do anything else in the way of short-circuiting it because, there's too big a backlog. I mean, query whether he should suddenly, having been given basic protections under reception, lose the lot, except in respect of the children under Articles 10 and the other one we looked at, unaccompanied children, whether they should suddenly lose all that.
Well, with respect that there are several things that to tease out of that, if I may. The first one is that the individual doesn't lose the lot because it is taking several years to deal with his application. Most of those benefits come to an end on final determination of his first application. He's simply not regaining them under our construction if he makes a subsequent application. But the other point is this, that although these cases come before your lordships in the context of cases which are taking several years to resolve, that will not be the position after the backlog has cleared, because new cases, that is to say cases now coming into the country, are being dealt with under a completely different system, in which the target is to deal, and that is to say complete the case within 6 months. And so that the backlog...
Subject to appeal.
The appeal system has also been brought into this so that it should all be resolved within 6 months. There are obviously going to be cases that are difficult, but even in that system, or indeed in any system, however perfectly it works, there are always going to be the inevitable delays, even of 2 or 3 days between one step and another, between, say, the receipt of the final judicial determination and the actual removal. Indeed, at earlier stages, you can't remove people immediately because you've got to give them time to appeal to the next stage, and that may be 2 weeks or 4 weeks, or time to allow them to seek judicial review if that is the remedy, there are timescales, similar sort of timescales to allow people to do that. And in any of those gaps, somebody might put in further representations. Now, the submissions themselves would have to be dealt with on their merits because, as I say, there are pre-existing treaty obligations that oblige us to do that. That's what the conventions say. But even in the best run system, it would still make no sense for every set of further submissions to trigger the reception directive all over again, every time. That adds to the administrative burden on the state, and it achieves nothing when that is happening. But if that is the consequence of the respondent's construction of the directive, which they have to accept it is, then we respectfully say that there is something wrong with that construction. And the solution to the conundrum, we say, when you put all of this together, is to recognise that the reception directive actually only covers a limited field, a limited scope. That is to say, the first time round applications.
Well, that's just about the end of that argument, Mr. Tam.
Yes, that's the end of the substantive argument.
Yes.
on the construction.
You want to say something about a reference?
About a reference, yes, because if your lordships are not with me on the construction of the reception directive, then we respectfully say that this is a case which clearly requires a reference to the European Court of Justice. The construction which we advanced found favour at first instance, but not before the Court of Appeal. And it is only in limited circumstances that this court should take on for itself the final decision about what a European measure means. And the reasons for that degree of caution were perhaps best expressed, or most succinctly expressed, in Chilfit and the Ministry of Health, which your lordships have in Authorities Volume 5 at tab 63.
Do we need to look at it? It's very familiar ground.
Well, I'm grateful. It's paragraphs 16 to 20 and then the finding at 21. We respectfully say that all of those reasons apply in this case, starting from the title of the of the directive and the meaning and importance of the English word reception, and in all of the other community languages, both those which we can, perhaps some of us can read and understand, going on to the ones which we can't even write. And all of that is apt to be considered by the court in Luxembourg. Indeed, the respondent ZO almost concedes that much at paragraph 169 of her printed case. When she's, paragraph 169
Of what?
of ZO's printed case, in which she accepts that the United Kingdom courts are simply not competent.
Sorry, 169 of...
It's page 53 of ZO's printed case. After having, we say, wrongly tried to play down the importance of other language versions of the directive, she goes on to say that absent expert linguistic evidence, a comparison in different language versions is a task which is beyond the competence of a United Kingdom court. And we respectfully say, of course, that is what the Luxembourg court is there to do. It can receive submissions from all the member states as to the meaning of the directive and indeed for the way in which they see it operating and the way in which they operate the directive in their own legal order. And of course the Commission has a voice there as well. And the court in Luxembourg is best placed to see this directive in the context of all of community law, including, but not limited to, the other measures in the Common European Asylum System and the other measures that we have been looking at. And it would be the court in Luxembourg who would be best placed to resolve the conundrum of trying to resolve the differences between the Reception Directive and the Procedures Directive, the different approaches that they have taken, one specifically dealing with second applications and the other one not, and considering whether, in truth, the Reception Directive ought to be regarded as applying to subsequent applications as well as to first-time round applications. And we say, given the whole history of this case and the amount of time that we have all spent in written and so far my oral argument, it demonstrates that the required degree of certainty is certainly not present, and that this court, being the first court that has had the power to make such a reference, should do so if you're against us on our primary argument.
Yeah.
Lords, that then concludes my argument on the directive. We've set out our position on the Article 8 argument, and I've alluded to it this morning. Yes. I'm entirely in your Lordship's hands as to the order in which you wish me to deal with matters, and I don't know if your Lordships would prefer to hear Learned Friends on the directive.
Well, I think we would. I think rather than divert ourselves to a new chapter, I think it's more tidy to complete the argument on the directives and see where we go.
Lord, yes, I'm grateful. Before I sit down, Learned Friends have asked me to mention one matter which is ancillary to these proceedings, which is the question of the anonymity of the respondents. Yes. Just to put it in a nutshell, our position is that on the facts of these cases, we have no objection to the respondents' application for continued anonymity in their cases. As a matter of general principle, these cases fall within the category of those whose identity or the confidentiality of whose identity from the governments of their home countries might well be important, and they fall into that territory. I'm happy to expand on that at some convenient time, if appropriate, but I've been asked to mention our position now.
Thank you very much.
Unless I can assist any further at this stage.
Thank you very much indeed. Mr. Beard, do you want to add anything? Thank you. Yes, Mr. Wilson.
May it please your Lordship. My Lords, on that last point, can I just say that is the position my client
Zodo would wish for confidentiality to be preserved.
And the reason? Can you just give a short reason?
The short reason is that that is the status quo coming into this case, and in terms of her identity, she would prefer it to remain so.
She would what?
She would prefer
I
it
know,
to
but why?
remain.
Why? I mean, we don't ordinarily anonymise cases unless there's a good reason for it.
Well, my lord, to the extent of her name being expressed as ZO,
Yes, but,
rather than her full name.
but I think one has to contemplate presumably what would happen if she were to be returned.
Indeed.
Is there a genuine fear that the release of her name might prejudice her position on return?
My lord, that's my understanding.
Oh, well, that is a reason. Might have given it.
Well, anyway, Mr. Tam hasn't objected to that. We'll consider whether we need any more from you on that. But
My lord,
let's
yes.
leave it that way for the time being, shall we?
Indeed. My lord, the definition of application for asylum is clear and precise. It applies to a subsequent application for asylum. The Court of Appeal was manifestly correct so to interpret it. The definition of applicant and asylum seeker is clear and precise, and the Court of Appeal's interpretation was correct. The Court of Appeal's interpretation is consistent with the Procedures Directive. It's part of a common European asylum system. It was accepted and properly accepted by the judge at first instance as being part of a common system where the procedures, one informs the other. The Court of Appeal were correct to find that it would be strange if similar definitions were to be given different meanings in respect of European legislation forming part of a common system.
Is there any European jurisprudence that you can introduce us to that deals with the problem which Mr. Tam relies on of the 10-month period when the one couldn't inform the other because the one didn't exist?
My lord, yes, there's the case of Silfit, which, my lords, can be...
Sorry, Silver, the case we just looked at.
Volume 5.
My lords, yes.
Volume 5, tab
it's-
70.
It's at tab 63.
Oh. 63, yes. All right. Yes, 63.
Authorities, tab 63. At paragraph 20, which sets out the basic proposition as a matter of principle. Every provision of community law must be placed in its context and interpreted in the light of the provisions of community law as a whole, regard being had to the objectives thereof and to its state of evolution at the date on which the provision in question is to be applied. What we say is that at the date that the Court of Appeal were determining the meanings of the expression, the term, application for asylum, there was community law in place, the Procedures Directive, which assisted it in determining that meaning. It would have been wrong in principle for the Court of Appeal to ignore the Procedures Directive simply because it was a provision which had been passed, a measure passed after the Reception Directive. And there is a further point which Richard Brent, in his book on directives, makes clear that in circumstances, as a matter of principle, where there is similar or legislation which forms part of a common group of European legislation, that it is appropriate to have regard to that legislation, even though it might have been passed subsequently. My Lords, that's at Authorities, Volume 6, and at tab 85, paragraph 1921, page 268. My Lord, where he states, under the heading legislation related to a similar field, where there are lacunae in community legislation, it may be appropriate to consider legislation in related or indeed the same fields, or even subsequent legislation to fill in the gaps. For example, in the absence of a definition in insurance and 6th VAT directive, the Court turned to the definition in Council Directive, another Council Directive as amended. And so he goes on in that paragraph to set out a number of examples.
Do we have any of the examples referred to in footnote 133 in the bundles? I mean, these are subsequent measures confirming the interpretation of previous legislation. It's just that I can see the general point he makes, but it would be interesting to know just what is based on.
My Lord, I'll just ask my junior to check that point once I continue.
He's shaking his head, so,
Shaking his head. No,
so
not.
we don't have that, but yes.
Well, my Lord, that can be obtained overnight.
Yeah.
So, my Lord, we submit that the position in relation to the procedures and reception directives, that it's not simply a case, as here, where one is dealing with a gap, or possible gap, but one is dealing with very closely aligned legislation.
Well, I'm looking, if I might just pick that up, at the same paragraph, 19.21, the first sentence of the next paragraph on the page. However, no recourse may be had to parallel legislation where no proper analogy may be drawn because the directives are adopted with wholly different objectives in mind. You would say, look at the preambles of these two directives. They are actually directed to the same basic issues. Is that right?
My Lord, yes. And both are pursuant to the Tampere meeting in 1999, and both have been put into law and effected in pursuance of the common European asylum system as a goal. And, my Lord, the close relation of the two pieces of legislation can perhaps be demonstrated with two particular terms, in respect of which there's no definition in the reception directive, and you have to go to the procedures directive to find a definition.
Well, before we do that, I'm sorry to keep interrupting you, Mr. Wilson, but if we look at the reception directive, page 1, footnote 1 is referring to the proposal from the Commission, because these directives, as we all know, begin with a proposal, and that seems to be dated the 31st of July 2001. Now, if you look at the procedures directive, the equivalent of footnote 1, you see exactly the same. No, you don't. You see, in fact, an earlier date, I think, but it looks as though they're very closely allied in time. There's a proposal the 27th of February 2001, whereas the reception directive actually seems to have come out of a later proposal. The point I'm making is that it looks as though the proposals were germinating through the Commission more or less contemporaneously. and perhaps the procedures got elaborated and extended in the case of the procedures one because it was longer, more complicated, but they seem to have had a common root, both in terms of what they were attempting to achieve and also in terms of timing.
My Lord,
And
that
I
is
suspect that in Luxembourg that's the kind of point they might be interested in, to see whether there was actually some common germination of the two ideas.
Well, my Lord, yes, there was a common germination in terms of all four pieces of legislation which form part of the common European asylum system. So that would include the Qualifications Directive in 2004 and also the Dublin regulation in 2003. And all four are pursuant to this, as we can see from the preamble. And in both cases, if one has open the Reception Directive preamble and the preamble for the Procedures Directive.
The first two paragraphs.
My Lord, yes.
Yeah.
And then they both refer to the special meeting in Tampere on the 15th, 16th October 99.
My Lord, yes. And at 3, the Tampere conclusions provide a common European asylum system should include in the short term. With this one, it was common in the Reception Directive, common minimum conditions of reception of asylum seekers, and in the Procedures Directive at 3, it relates there to procedures, common minimum procedures, fair and efficient asylum procedures.
It's quite interesting, actually, that the European Economic and Social Committee delivered an opinion on the Procedures Directives some months before it delivered its opinion on the Reception Directive.
My Lord, yes.
So at that stage, the order of appearance was reversed.
My Lord, yes.
Article 63 set out in Tam's case at paragraph 24.
And, my Lord, I'm hopefully reminded by my friend that as paragraph 24 of the appellant's case, that the legal basis of the Reception Directive and related procedures are set out. And it's pursuant to the treaty establishing the European Union,
Yes.
which sets out the four measures which would be adopted, each of which relate to the subsequent directives and Dublin regulation which have come into force. So, my Lord, simply by way of outline, and I will come to my substantive submissions, we submit that the interpretation of the Court of Appeal is consistent with the Procedures Directive, which the Secretary of State now accepts, treats a subsequent application as an application for asylum. My Lords, in terms of the interplay between the two directives, just by way of two examples, in the Reception Directive, Article 2C, the definition of applicant or asylum seeker, it is said, and the final clause there, in respect of which a final decision has not yet been made. Final decision is not defined in the Reception Directive. You have to go to the Procedures Directive to find the definition, and it's at 2D. Similarly, my lord,
Sorry, just hold on a second.
yes,
And the remedy within the framework of Chapter 5 is an appeal remedy.
it's the appeal remedy, my lord.
Does it, well, it gives it that definition because it directs you to bits of the procedure directive that deal specifically with appeals and so on. It wouldn't be necessary to spell that out in the reception directive.
It wouldn't be. But what it demonstrates is the integrated nature of the two pieces of legislation. My lords, also with regards to Article 11, the employment article of the reception directive, that refers to a decision at first instance having not been taken. Decision at first instance is not defined in the reception directive. And we have to go to the procedures directive in order to see what a procedure at first instance is. And if your lordships turn to Article 23, your lordships will see that Chapter 3 is headed Procedures at First Instance, which sets out a number of procedures which, at first instance, which runs up to Article 36. So, my lords, we say that at a fundamental level, it is important to read the two directives together. The provisions are integrated. They were made and brought into law pursuant to a common policy and pursuant to a provision in the Treaty of the European Union. They are to be understood as similar, very closely related pieces of legislation. The reception directive deals with the substantive rights and duties with regards to reception conditions. The procedures directives deals with the minimum standards for procedures in relation to the granting or withdrawing of refugee status. My lords,
Can I just ask, I mean, assume the Secretary of State under the Procedures Directive, Article 25, is entitled to regard an application as inadmissible, right? What, if any, obligation is he under in respect of the Reception Directive?
none in respect of that application. If it's in an inadmissible application, we can see at Article 25, first of all, that he's not required to examine whether the applicant qualifies as a refugee. If it's inadmissible, he's therefore not an applicant within the meaning of Article 1C of the Reception Directive. That is, he's not a person or can't be treated as a person who has made an application for asylum in respect of which a final decision has not yet been made.
Sorry, Howard.
I see. Well, I mean, until it's ruled inadmissible, he
Yes.
is an applicant.
Until it's ruled inadmissible, but once it's ruled, I understood my lord's point to be, if it's ruled inadmissible in the context of Article 25, if it's ruled inadmissible, what happens? Procedurally, it means that the Secretary of State, having so ruled it, having considered it inadmissible, is not required to examine whether the applicant qualifies as a refugee. And if he's not required to examine that, yes, if he's not allowed, if he's not required to examine whether the applicant qualifies as a refugee, there appears to be no basis on which that person could be entitled to remain in the member state concerned.
But meantime, if you look at the reception directive, Article 6.1, within 3 days of this inadmissible application being lodged, all the documentation has to be reeled out. I think that's part of Mr. Tam's objection. He says it's ridiculous. Really, if you've got an inadmissible thing, it's obviously going to take time to rule that it is inadmissible, but meantime, you're under this strict instruction within 3 days to ensure that the documentation is delivered.
My Lord, the short point is, until it's ruled inadmissible, it's not inadmissible. It's either ruled inadmissible or it's not. If it's not ruled inadmissible, what we have then is a subsisting application within the meaning of Article 1B.
Well,
and we have an applicant within the meaning of 2B and 2C, an applicant there.
Well, that's another way of saying that Mr. Tam just has to accept that the system doesn't provide for any screening until the application is ruled inadmissible.
My Lord, yes. And for it to be any other way, it's difficult to fathom how that could work. How can it be treated as inadmissible until it's actually ruled as inadmissible? Until that point, there is a subsisting application, and the third country national concerned is an applicant, an asylum seeker within the meaning of the reception directive. If, of course, the procedures are working quickly and efficiently, the application will be declared inadmissible relatively quickly.
Sorry.
Now, at that point, you concede, or indeed aver that he no longer is to be regarded as an applicant or asylum seeker within the meaning of Article 2 of the Reception Directive, once it's ruled inadmissible.
Well, my Lord, yes, because if it's inadmissible, then there's not an application in respect of which a final decision is pending in terms of Article 2C.
No, I mean, he has, within the meaning of Article 2C, he has made an application, but it's not one in respect to which a final decision has been, is that it?
My Lord, yes.
I see, not yet.
Yes.
Because
it's lapsed as being inadmissible.
yes, so it doesn't even get there. It doesn't get to or once one reaches that point and it is ruled as being inadmissible or considered inadmissible, at that point there's no application in respect of which a final decision is pending within the meaning of Article 2C.
Right. Well, I'm sorry, just, and then I shall keep quiet, but just a supplementary. If it's not treated as inadmissible, but it's fast-tracked under Article 32, okay, subjected under 32.3 to a preliminary examination, and having been subject to that, it doesn't fall within 32.4. In other words, there are no new elements or findings which significantly add, etc., etc., etc. So he doesn't need any further examination. Now, what's the position then vis-à-vis the reception directive?
My Lord, the position is that under this procedure, if the preliminary screening process is put in place, then the member state doesn't need to examine the application any further. And that's it. It's a preliminary screening process in accordance with Article or Preamble, Recital 15.
Sorry, hang on. Yeah, so again, I mean, what's the position under the reception directive if under 32 you don't need a further examination, then what? Under the reception directive, is he still entitled to the protections?
Well, there are two things. Firstly, a final decision, once a final decision is made, so it would be, let's say for instance, the preliminary screening procedure is put in place, that it is deemed or found not to raise new elements or findings, the member state concerned is not then required to go any further with a full procedure, and a decision can be made at that stage on the basis of a summary preliminary procedure on the merits of the application. So at that stage, a decision is made.
I see from Article 24, 1A, that this is a derogation from the ordinary procedure which is set out in Article 23. In 23 is the normal procedure, as I understand it, for
My Lord, yes.
an adequate and complete examination, but one can shortcut this in the procedure allowed for under 32.
Yes, my Lord, it's similar, I suppose, if one were to draw a domestic analogy, with, say, a summary, an application for summary judgment, an application for full trial. And what's been done here is given to member states in cases where, on the face of it, nothing new is being said, to say, right, we're going to deal with it on a summary basis, that's it, it's over, we've made our decision. And they're not then required, as my Lord has noted, to go through the full procedure,
No.
what would equate domestically to a full trial.
So once again, 32, adverse decision, therefore doesn't fall within the compass of the reception directive because a final decision will have been taken. Is that right?
My Lord, yes.
But then again, he might make another application. And I don't know, I suppose might be again knocked out under 32 or indeed knocked out under the earlier one as inadmissible under 25. I mean, the position is it that, I mean, he can go on doing that as long as he likes, but the Secretary of State will be able actually to deport him if he manages to get it in time.
Well, my Lord, he will be able to deport him under Article 7.2 of the Procedures Directive.
Sorry, under
7.2.
Yes. In accordance with Article 32.
Hang on.
Oh, I see.
I see. Wait a minute. Can we allow to remember? Oh, goodness. Remember said so, but (32) and 34. It doesn't mention 25. Well, I suppose I would say it doesn't really need to.
Doesn't need to, because it's inadmissible.
34.
So 34 is ancillary to 32. is it?
Yeah.
But this is only when the Article 32 process has been completed.
My Lord, yes.
And I think you do. I think you accept, don't you, that whether under 25 inadmissible or under 32, short process. If an application has been made, then until it's been completed by one or other of those routes, it is an extant application.
My Lord, yes.
And the making of that application will trigger the entitlement to these benefits, including, for example, within 3 days, the new certificate of asylum status.
My Lord, yes.
You do accept that. So
I do.
that in an extreme case, you could get the abusive applicant doing it over and over again with the repeated obligation on the state to perform its obligations.
Yes, my Lord, in an extreme case, one would probably expect procedures to be in place to identify abusive applications of that nature relatively quickly. But with regards to the substantive point being made by my Lord, that would appear to be the position under the procedures and reception directives read together.
So Article 16(1)(a) doesn't arise then?
Of the reception directive?
Yes.
My Lord, that is dealing with a situation where there is more than one application being made at the same time before a decision has been made on the first one. That's
You essentially accept Mr. Tam's position on the third bullet point in 16(1)(a), where it refers to has already lodged an application in the same member state.
My Lord, yes, because if one reads it, it refers to already lodged. It doesn't go on to say, and in respect of which a final decision has been made. It uses the expression lodged, and given that word its ordinary meaning, it would mean that there's an outstanding application. If one were to use it or think in terms of even domestic procedures, one lodges an application at court. That doesn't imply that a final decision has been made in relation to it. In fact, the opposite. It means that you've got an application which is lodged and in respect of which examination or decision of it will be made in due course. So, my Lord, our view is that in reading that, it would appear to be that there's a first application made, that's the one referred to as already lodged, and then there is a subsequent application made. And in respect of both of them, there is a decision, a final decision is yet to be made. And, my Lord, that is certainly how the Secretary of State in domestic legislation has interpreted Article 16(1)(a) third tier, or third bullet point, in the legislation, the secondary legislation, which implemented Article 16. And he's interpreted it as, in terms of the legislation,
yes,
as a first application for asylum, or uses the expression a first claim for asylum being made, and then before there's a decision on that first one, a second application or claim is made. And we make that observation and in passing note that the way in which that legislation has been worded and implemented is consistent with our submission that the reception directive within its provisions clearly contemplates and treats a subsequent application for asylum as an application for asylum within the meaning of the directive.
Could we look at the legislation, please?
My Lord, yes. Just give me one moment, my Lord. Yes, my Lord, authorities at tab 15
1.5.
1.5, my lord. That's volume 1.
Yes.
And my lord, it's dealt with at Regulation 6, and that's at the foot of the third page, where we can see suspension or discontinuation of support. And then at 21, it reads, asylum support for a supported person and any dependent...
Sorry, I'm lost.
Oh, I'm sorry, my lord. Tab 15...
Oh, I see 20,
20 at the foot
subparagraph
of the
1.
page, my lord, yes.
Sorry, yes.
Asylum support for a supported person and any dependent of his, or for one or more dependents,
Yes.
I think it has skipped a
gone
page.
wrong.
It's gone.
There's bits missing.
Oh,
but
no, wait a minute. Or is it the next 2 pages are transposed?
I think that's probably
Yes,
right.
I
I think
think
Lord
that's
Brown's
what's
right. But
happened.
it's little j that matters, isn't it?
It's little j, my lord.
I-
So if we go to j, which... now,
We have to read,
yes.
we have to read, when of a supported person may be suspended or discontinued if little j.
and then go to little j.
Yeah.
Yes. The Secretary of State has reasonable grounds to believe that the supported person or a dependent of his for whom support is being provided has made a claim for asylum, the first claim, and before the first claim has been determined, makes or seeks to make a further claim for asylum, not being part of the first claim, in the same or a different name.
So can we take it then that you accept that interpretation? Really, what Mr. Tam was suggesting to us is the correct one.
Well, my lord, yes, but we say it has this significance in the context of this case, and that is that the Article 16, we would say, clearly deals with 2 applications for asylum, both one which is a first application, which is an application within the meaning of the directive, and the second application is also treated as an application for asylum within the meaning of the directive. So we say that within the directive itself, there is clear evidence that a subsequent application for asylum is an application for asylum within the meaning of the directive.
But that's before either of them have been determined at first instance.
My lord, yes.
And his point, this...
I don't have any dispute about that. I mean, Mr. Tam, I think, accepts that if you make, so to speak, further applications before a first decision, then it is within the reception directive.
Yes, my lord, but the point is it an application for asylum? And we submit it clearly is an application for asylum. And, my lord, we can arrive at that conclusion by looking at Article 16, and just going through it, and in particular, the terms asylum seeker and has already lodged. So, my lord, Article 16. Where an asylum seeker, what's the definition of asylum seeker? An asylum seeker is a third country national or stateless person who has made an application for asylum in respect of which a final decision has not yet been made. So, who has made an application for asylum. So, within the definition of asylum seeker there, that person is someone who has made an application within the meaning of the reception directive. We then go down to the third bullet point, which says, has already lodged an application for asylum. Therefore, we are dealing with at least 2 applications for asylum, the first one which has been already lodged, and the subsequent one that the person who is described as an asylum seeker is now making. It cannot be read in any other way than that there are at least 2 applications for asylum which are involved in Article 16.
Well, what are we to take from that of the situation where the asylum seeker had already lodged an application in the same member state which has in respect of which a final decision has been taken? That isn't covered by the relief that's available under 16(1)A, third bullet point.
My Lord, no.
But is there any relief at all, or do you just have to go through all the reception conditions all over again?
Well, my Lord, there is relief in the form of the Procedures Directive. Because if one looks at it in practical terms, an application for asylum has been refused. Therefore, that person who was an asylum seeker, whilst a final decision was pending, now reverts to the status of third country national. There may be a period of time between the first application and any subsequent application, but all benefits, all conditions, minimum conditions, will fall to the ground upon a final decision on the first application. So until a second application is made, no reception conditions will apply. Now, if a second application is made, then the sense of the directives, procedure and reception, is that there ought to be in place minimum conditions, which these are, until such time that some sort of decision has been made. Because, as we have seen, for instance, on the facts of the cases before your lordships, there may be a very considerable period of time whilst a state, perhaps because of policy, perhaps because of inefficiencies, might not actually make a decision or even look or screen the application to see whether in domestic parlance it is a fresh claim or whether in the language of the Procedures Directive it raises new elements or facts. So in those circumstances, the sense of the directives is upon a subsequent application being made, or any application for asylum being made, the minimum conditions in the Reception Directive begin to operate. It's then up to the member states how efficient they are in processing this, because if one takes it at the highest point, there could be a system in place where an application comes in today and within a week a member state may make a decision in relation to it. The member state could treat it as an inadmissible application and clearly abusive, or could subject it to a screening, a preliminary screening process. Now, my lords, it will be significant when we look at the range and we say powerful range of procedures which are available to member states to deal with the possibility of abuse in the context of the Secretary of State's policies and decisions. And there are 2 in particular. The Secretary of State, when transposing the Procedures Directive into national law, chose not to implement the special procedure in Article 32. Also chose not to implement the procedure 23, I think that's 23(1)H, which we can see in the Procedures Directive. It's where the applicant has submitted a subsequent application which does not raise any new elements with respect to his or her particular circumstances, where they could prioritise or accelerate that. Now, it may be that the Secretary of State may have felt that he or she had adequate procedures in place, but that's not the issue with respect before your lordships today. The question is, in interpreting this legislation, is whether the legislation provides for the dealing with cases of potential or the possibility of abuse. And the basis of our submission is that there are a full panoply of procedural measures which are addressed to deal with that. So, my lords, and whilst I'm on it, it may be as well to deal with it now in terms of what there is in the Procedures Directive. Your lordships have already been asked to turn to recital 15 in the Procedures Directive, which gives member states, which indicates that member
Sorry,
states...
it's my fault. Can you just say that again? I was reading something different.
My Lord, yes. My Lord, recital 15 of the Procedures Directive, if we just look at the range of procedures which are available and specifically directed towards subsequent asylums, subsequent applications for asylum. And we begin with recital 15. My Lord, there is then Article 7.2 that we have just looked at a moment ago. There is Article 23.4h, and which is dealing with the prioritisation or acceleration, and my Lord Hope has already pointed to 4E, that's 23.4E. My Lord, as we go through these, we are specifically identifying subsequent applications for two reasons. The first one is to demonstrate, I think the point is now being conceded, that subsequent applications are treated as applications for asylum within the Procedures Directive. But, my Lord, the other point which needs to be underscored is this, that there are a whole range of procedures which will apply to all applications for asylum and not simply subsequent applications. So, for instance, procedures at first instance, all those procedures can apply to a subsequent application as much as they can to a first application. And we see the whole range of things. For instance, if we look at 4C, that's 23.4C, the application for asylum is considered to be unfounded because the applicant's from a safe country of origin, and so on. So, by focusing, as we are, on subsequent applications, my Lord, sight should not be lost of the fact that there are other procedures here which also apply to subsequent applications. So, my Lord, continuing to look specifically at subsequent applications, at Article 24, specific procedures, my Lord, Lord Hope has already referred to 24.1a, which is a reference to subsequent applications in Section 4. We have already looked at Article 25, inadmissible applications, and the making of identical applications at 2F, which meets the point which was being made by my learned friend Mr. Tam, that, oh well, asylum seekers, they can just make an identical application and then the Secretary of State will have to go through all the procedures in relation to examining it. That's not the case. If it's an identical application, it can be treated as an inadmissible application, and that person then would cease to be an applicant within the meaning of the Reception Directive. Then, my Lord, always bearing in mind, as I've just stated, that all these provisions will apply to subsequent applications. For instance, we've got Article 28 on founded applications. The person doesn't qualify for refugee status.
Sorry, which one?
That's Article 28, my Lord. And then again at Article 32, which deals, this one deals specifically with subsequent applications, and we've already looked at that. My Lord, perhaps this can be said. Our reading of Article 32 is that it is making a distinction between further representations which may relate to an extant application for asylum and a subsequent application which is in itself a new request for international protection, a new application. And so further representations, there's an existing case, something further happens perhaps in the home country, and the person concerned wishes to send in further representations to support an existing application in respect of which no final decision has yet been taken. And, my Lord, Article 34 is important in terms of who is or what constitutes an applicant for asylum or an application for asylum, because Article 34(1) states that member states shall ensure that applicants for asylum whose application is subject to a preliminary examination pursuant to Article 32 enjoy the guarantees provided for in Article 10(1). So applicants for asylum are treated as someone who has an application which is subject to the preliminary examination. What is subject to the preliminary examination is a subsequent application. So Article 34 treats as an applicant for asylum a person making a subsequent application for asylum.
Yes.
The 10(1) guarantees are various procedural guarantees.
My Lord, yes, that's the basic guarantee from which a member state may derogate, for instance, pursuant to Article 24(1)(a), where there's been a preliminary examination for a subsequent application under Article 32.
Yes, where do we go from here then? Is there anything more we want to take out of the Procedures Directive?
My Lord, no. My Lord.
Could I just clarify something before we go on? The Procedures Directive is littered with references to Directive 2004-83 EC, which is the Qualification Directive.
My Lord, yes.
Looking at the front of Volume 4, Item 48, which is between the two we've been looking at, I suspect is intended to give us the Qualification Directive.
My Lord, yes.
Although it actually says 204-38 and not 83, And if you look at tab 48, at any rate in mine, we haven't got either 38 or 83, but 58.
My Lord, yes.
That is a mistake, I
It is a
assume.
mistake, my Lord, and it's to be found, the Qualifications Directive, at tab 95.
Thank you.
Bundle 7.
Oh, 7, is it? No. 95.
So you spotted that and put it in at the end.
My Lord, at least my junior did. Yes. Grateful.
Yes. Is there anything particular you want to take out of what we just looked at, tab 95?
My Lord, no. My Lord, where we go from here is to the question of whether or not the Court of Appeal's interpretation was consistent with a number of things. We have already said that, submitted, that it's consistent with the Procedures Directive, and we submit it is consistent with the purpose at Article 1 of the Reception Directive.
Are we going to start looking at a subject in more detail now? Because I wonder whether we should just break off at this point. I take it we've got ample time tomorrow to complete your argument. I think since you're changing tack, as it were, it might be more tidy to look at it in one piece tomorrow morning.
My Lord, so be it.
Well, we look forward to seeing you at 10:30 tomorrow.
Thank you, my Lord.